Will a father have a chance at winning the custody battle? Some say yes, some say no. So I will present to you an outline of which for winning the custody battle. Now, I'm not an attorney and I don't play one on TV, but this is my guide for winning the custody battle. Now, the custody battle, I'm going to outline the perspectives of a divorce or an unmarried person. Of a father, let's consider this. If you have children, whether you're going through a divorce or you're unmarried, they're going to put you on child support. And the reason is because of the incentive pool in all of the states, which is 42 USC 658.A, which is called the incentive pool. And the incentive pool has $713 million.
For fiscal year 2024, the incentive payment pool is established at a total of $713 million. This pool represents the funding that will be distributed to states as financial incentives for their performance in child support enforcement programs. The incentive payment pool is designed to reward states for their effectiveness in managing child support enforcement programs, with a focus on performance, accountability, and accuracy. For fiscal year,
if you're getting a divorce or if you're unmarried and you're going to go your separate ways, my opinion is to get a certified public accountant as soon as possible. Let's face it, you're going to be separated, so you have two separate households, and we need to know what the issues are, what the bills are. If you cannot do a certified public accountant, then consider a tax professionals. Again, you're going to be, you're separating, you have two separate households, you have bills to pay, so consider a tax professional. You need to know what the finances are. You need to know what your bills are. When you're going through a breakup, let's discuss married versus unmarried. And I'm going to discuss unmarried later on. You are separating and you have kids. The state has a program, it's called the Title 4D program, and they presume that you have abandoned your children or your child. The purpose is to separate children from their fathers. Let's start at the beginning. Where did they get the idea that you have abandoned your children? Let's start at the New Deal.
The program was created under the name Aid to Dependent Children, ADC, by the Social Security Act of 1935 as part of the New Deal. It was created as a means-tested entitlement which subsidized the income of families where fathers were deceased, absent, or unable to work. The federal government required authorized state discretion to determine who received aid and in what amount. In 1961, a change in the law permitted states to extend benefits to families where the father was unemployed, a measure which 25 states eventually adopted. The words "families with" were added to the name in 1962. The program was created.
I managed to get a copy of those laws. It's called the Criminal, Child Neglect, and Abandonment Laws. It was last updated on September 14th, 2024. And it reads, failure to protect or to pay court-ordered child support. This is the Abandonment Clause. Let's preview the Abandonment Laws. So you'll see Alabama, Alaska, Arizona. These are the codes that child support will use for the Abandonment Clause. Just give you a sample of the abandonment clause. We're looking here for New York, which is the Consolidated Laws, which is Penal Code 260.05, which is non-support of the child in the second degree. While you're going through the separation, you need to discuss earlier on your child support and the visitation schedule, because the judge is going to think that the father's going to have the child every other weekend or every weekend. The goal is to put you on child support, whether it's Article 3, which is divorce, or Article 1, which is child support. The reason why I say divorce is Article 3 and then child support is Article 1, eventually you're going to end up on child support, which is Article 1. We have a video called Understand Jurisdiction. Jurisdiction is the cornerstone of our judicial process. Next, we have another video called What is the difference between child support, custody, and visitation? Preview that video. In this presentation, we're not going to discuss paternity fraud, because I have another video that's called Paternity Fraud, A Man's Nightmare in Tennessee. It's not going to be discussed in this presentation. You have to check out this video. For the video in Tennessee, we reviewed Travis Jones versus the state of Tennessee. In other words, the father sued the mother. Check out that video. Also, I have another video, which is Candace Owens is wrong about child support. I'm not being political. Candace Owens is a very nice woman, but I disagree with her opinion on child support. Check out that video. Eventually, you'll be on child support. So we're introducing our study guide. You need to study the child support process. Remember, whether you're going through unmarried or a divorce, when you're separating, the state will put you on child support. So you need to study 303.52, which is the incentive political subdivision. Item 303.71, 303.72. Study them. This is our study guide. Hello, my name is Chris, and in this session, whether you're going through a divorce or you're unmarried, you need to avoid the child support. And in this session, I will step you through the process of how to win the custody battle. Tune into our podcast at childsupport.newshandler, which is available on Spotify, Amazon, and Apple. We have an app where we detail in-depth articles or case laws. It's located at childsupport.newshandler.com. Let's start with marriage. We will discuss the unmarried later on. In the marriage, you need to discuss 50-50 child support at your earliest when you start the divorce. Don't wait till later. Just demand custody and visitation early. Eventually, as you're going through divorce, they want to put you on child support. That is the goal of the state. So here's the case law. Blessing versus Freestone. Child support has nothing to do with the mother or the child. While you're in the circuit court or the Supreme Court, the judge will issue what is called a temporary custody order. You want to get that squared away. You want it to be a permanent custody order. The thing is this, always remember, paternity equals support. You just want the custody order turned into a permanent order. While you're negotiating temporary custody order into a permanent custody order, you can use the landmark case Santosky versus Kramer. It's from the Supreme Court.
As a parent, I have the fundamental right to raise my child, just as my child has the inherent right to be raised by me. This bond between parent and child is deeply rooted in our connection, and it reflects not only a responsibility but a cherished privilege. I hold a vital interest in the care, upbringing, and custody of my child, ensuring that they grow in a loving and stable environment. At the same time, my child has a parallel right, an important liberty interest in not being unjustly removed or separated from our family. This right safeguards their emotional and developmental well-being, ensuring that they remain with the people who know and love them most. Any unjust interference with these rights is not just a personal affront, but a violation of the 14th Amendment of the United States Constitution. As a parent, I have
Use the landmark case Santosky versus Kramer. If the judge interferes with your child support or the child support awards or anything, you can use your 14th Amendment.
The 14th Amendment. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States. No state shall deny to any person within its jurisdiction the equal protection of the laws. The 14th.
Let's turn our attention to the unmarried or never married. So this is the start of the child support program, what is called the establishment of paternity. And always remember, you do not want to participate in the child support program. If you are not familiar with the history of child support, preview that video. Oh, by the way, if you think the mother put you on child support, think again. The mother did not put you on child support. The state put you on child support because you have to send the money to the state. So preview our video. Mother did not put you on child support, part 1. Here are the reasons why I say that the state put you on child support. The case statute is 45 CFR 264.30. It says that the state agency may refer all appropriate individual in the family of a child for whom paternity has not been established or paternity shall be established. So the individual, what is the individual? Well, mostly men, 100% men. That's why child support does not involve women. It only involves men. As a reminder, it's all about the money. Paternity equals support. (28 USC 1654). In all courts of the United States, a party may plead his case on its own or personal with or by counsel, which is you can plead your case yourself. You can go to court yourself. If you have counsel, it's okay, but you can plead your case yourself. 28, you have the right to access the court at any time, and the case law is called Biffle versus Morton Rubber Industries.
The right of access to the courts is basic to our system of government, and it is well established today that it is one of the fundamental rights protected by the Constitution. I have the right to access the court at any time. This means that legally, a document is considered filed at the moment it is delivered to the clerk, even if it hasn't been officially marked as filed yet. This principle ensures that my ability to engage with the judicial system is not hindered by administrative delays or technicalities. The right to access the courts is a cornerstone of our system of government. It is a fundamental right that is firmly established and protected by the Constitution. This right guarantees that I, along with every citizen, have the ability to seek justice, challenge injustices, and have my voice heard in a court of law. It underscores the importance of an open and accessible judicial system as a key component of a fair and democratic society. The case laws are Biffle v. Morton Rubber Industry and Rilland v. Shapiro. The right of access to the courts is...
Child support is a federally funded program. Plain and simple. Child support is a federally funded program. This leads me to another U.S. Supreme Court case. It's U.S. versus Sage. Child support is an agreement which is equivalent to an interstate contract, and they reject the idea that it's nothing more than a contract. U.S. versus Sage. So we discuss U.S. versus Sage and Blessing versus Freestone. So you need to know the rest of them. There are 5 Supreme Court cases that you should already know. You need to, my recommendation, you need to study that. So if you want to win the battle of custody, you need to know that. If you're unmarried in Georgia, they do things a little bit differently. They call legitimation process. And you can watch that video. I'm not going to discuss it here, but you can watch the video. They do something where in other words, if you're unmarried, the father has no rights unless you file for what is called legitimation. The father has no rights to parent, has no rights to education. You can't select medical needs, and you can't select additional activities. However, I'm not going to discuss it here, but in Georgia, they do things a little bit differently. If you're unmarried, when you're unmarried, the father, quote unquote, is designated in 4 phases. 1, the presumed father. Next, the alleged father. 3rd, the biological father. And 4th, the legal father. Only the legal father pays child support. All the other 3, they categorize them accordingly. But only the legal father pays child support, which is the contract. When you're unmarried, the next step is the establishment of paternity. The codes are 45 CFR 303.5. Now, it's called a title for the agency. Now, if you're not on TANF F or food stamp, then there will charge a fee for that. And the fee, I think, is about maybe $35. There is a provision that says it's going to be $45, but nevertheless, if you're not on TANF, they're going to charge you. Once they establish paternity, then you are on child support, which is the enforcement, which is Title 4D. And here is the case law, I'm sorry, not the case law. Here is the statute, 45 CFR 302.112, single and separate unit. This is as of child support. So they establish paternity, and then they put you on the child support program, and it says single and separate agency, and the state plan shall provide the establishment or designation of a single separate agency organization which administer the child support plan, and it's referred to you by the child support agency. So it's not part of the state. It's a single and separate program. Let me introduce you to a case. It's called Stephen versus Caroli. And the ruling was the support magistrate needs to refer all issues to a judge. The support magistrate or commissioner can only determine the child support, which is a Title 4D, but a judge determines custody and visitation. The reason is because it lacks jurisdiction and it needs to be vacated. Okay? Lacks jurisdiction. I suggest to preview my video, jurisdiction. Jurisdiction is the cornerstone of our judicial process. This next case is Lillian versus John. It was decided in 1997. So a support magistrate or commissioner cannot hold you in contempt because it's unconstitutional. It needs to be decided by a judge. So the determination of support magistrate or commissioner cannot incarcerate you because it has no force or effect at law, which means they're nothing but a glorified attorney who is deciding a contempt hearing. If you are battling the custody dispute, this is the case law that you will use. My opinion, this is the case law that you will use. It's called Stanley versus Illinois.
In Stanley versus Illinois, the United States Supreme Court considered whether a state law presumption that unmarried fathers weren't fit guardians violated the Constitution. Peter and Joan Stanley lived together off and on for 18 years and had 3 children together. The couple never married. When Joan passed away, the state of Illinois took custody of the Stanley children based on a state law that presumed unmarried fathers weren't fit guardians for their children. Illinois law had processes in place to take children into state custody on the basis of neglect or dependency. For neglect, the state could remove a child from the parents following proper notice, a hearing, and a finding that the parents were unfit. Dependency removal was permitted if a child had no living parents or guardians. The dependency statute defined parents in a way that excluded unmarried fathers. Therefore, Peter wasn't considered to be a surviving parent, and his children were taken into state custody without any notice or finding that Peter was an unfit parent. Pursuant to a state dependency hearing, Peter's children were declared wards of the state and placed with court-appointed guardians. Peter appealed, arguing that he'd been denied his rights to constitutional due process and equal protection. The Illinois Supreme Court affirmed the guardianship proceeding.
The battle for custody is not going your way, then you have a right to sue and to defend yourself in any courts. You know, it's your right. My suggestion, if the agency is interfering in your rights, then you can file a lawsuit. You can file a lawsuit under 42 U.S. Code 1983.
Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory subjects or causes to be subjected any citizen or other person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and its laws, is liable to the party injured at law, suit in equity, or other proper proceeding for redress. In any lawsuit brought, the plaintiff must prove that he or she has been deprived of a right secured by the Constitution and laws, and secondly, that the defendant was acting under color of any state law.
The Title 4D agency declared qualified immunity. They have qualified immunity. This is far from the truth.
Absolute provides legal protection to judges, prosecutors, legislators, and some executive officials for actions committed in their official duties without malice or corrupt motives. Absolute immunity protects these individuals from both criminal prosecution and civil lawsuits. Qualified protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated clearly established law. The plaintiff must prove, 1, that he or she has been deprived of a right secured by the Constitution and laws, and 2, that the defendant was acting under color of any state law.
This is my opinion on winning the custody battle, and I know I gave you a lot of information. So, as a result, you can schedule a call with me. If you have any questions or comments, please feel free to reach us at chrish@289.protonmail.com. Also, please subscribe to our YouTube channel and hit the notification bell. Also, we're asking for donations. We're asking for donation of $25 gift or any amount that you will provide. We appreciate it.